All right, they have to bring them out.
All right, we got you.
All right, let's bring them out.
Oh, no, you can't.
Yeah, I need for you to start the video. Okay, I'm gonna hang up on myself.
Yes, please.
We're gonna do it the same way you would. Come on, put things on your mouth.
We're ready, Judge.
Okay, can everyone hear me?
Yes, ma'am.
Okay, sorry about that. We'll have to start this over. I was having some technical difficulties. Let me have everyone please raise your right hand. Do you swear or affirm that the information you provided on your application of counsel and the information you're going to provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God? If so, say I do.
I do.
All right, thank you. Everyone may be seated. Good morning. It is April 19th, 2020. I'm Judge Xavier Fox. I'm here to preside over your first appearance hearings this morning. I want to go over a few things with you so you understand the nature of these proceedings. I am not here to try your case this morning or to take a plea in your case. Instead, I'm here to determine if you require the assistance of a court-appointed attorney to let you know what your charges are, to let you know if you have a bond, and if so, what that bond amount is, and to let you know what your next court date is. I also want to advise you of certain rights that you have. You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. The right to indictment by grand jury for most felonies or by accusation for misdemeanors. The right to a speedy and public trial by jury. The right to see, hear, and cross-examine all witnesses that are called to testify against you. The right to compel the attendance of witnesses in your own behalf by subpoena. The right to testify and offer other evidence in your own defense should you choose to do so, but not to, no presumption of your guilt may be raised. The right to have an attorney represent you. And at this point, I'm going to appoint a court-appointed attorney for all of you. If you choose to retain the services of a private attorney, once that attorney files an entry of appearance with the court, your court-appointed attorney will be relieved from representing you. Some of you will be allowed to post unrestricted bonds for your release from jail pending prosecution of the case, which may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond in cash together with all applicable mandated fees to the sheriff's office, who will hold it until your final court date, at which time the cash bond will be returned to the person who posted it. If you use a commercial bonding company approved by the sheriff, someone will have to pay the company up to 15% of the total bond as their fee for their service. This fee will not be returned. Someone may post a bond using their property if they have net equity in the property in an amount equal to 3 times the amount, the total of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to or around certain places. This special condition will be provided to you on a separate form. You will also be prohibited from calling or having other contact with the victim while you are in jail. Should you violate the court's order, your bond will be revoked and you will not be entitled to another bond while you are awaiting trial. An additional charge of aggravated stalking, influencing a witness, or other charge as the law may provide could be brought against you, for which you could be sentenced up to 10 years in prison and fined up to $20,000. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a superior court judge, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set a bond. Your bond can be reconsidered after your probation officer has an opportunity to determine if they wish to file a warrant for violation of your probation, usually during your preliminary hearing. The purpose of the preliminary hearing is to determine if there is enough evidence or probable cause to justify keeping you detained until such time as your case goes to trial. For those of you that are charged with misdemeanors only, you will have the option of waiving your preliminary hearing. Waiving your preliminary hearing will not affect your right to post bond, your right to have an attorney represent you if you qualify, or your right to a jury trial. If you post bond, your preliminary hearing is automatically waived, and you will be mailed a notice when to appear in the state court for your arraignment. If you cannot make bond, you may waive your preliminary hearing and be taken before a state court judge, at which time, if you plead guilty, you will be sentenced. If you plead not guilty, a trial will be scheduled. For misdemeanor cases, your preliminary hearing date is scheduled for June 1st at 8:30 in courtroom 201. For felony cases, your court date is scheduled for May 26th at 8 o'clock in courtroom 203. For felony cases, you will not have the option to waive your preliminary hearing at today's hearing. You will have to speak with an attorney first before you decide whether or not to waive your preliminary hearing. All right. Okay, those are all of the rights. I'm going to start with Terrence Raymond.
Raymond.
Or do you want me to do the females first since they're sitting right here?
Yeah, that's fine.
Okay. Sorry, Mr. Raymond. All right, let me have Rebecca Bridges.
Stay by that door. Stay by that door.
Who, me?
Yeah, stay by the door. Call your name, stay by that.
All right. Good morning, ma'am.
Good morning.
All right, are you Miss Bridges?
Yes, ma'am.
All right, do you know what you're charged with?
A little bit.
Okay. Ma'am, you are charged with criminal trespass. I'm giving you a $1,500 signature bond, so you will be released on your own recognizance. Ma'am, do you waive formal reading of the charges?
Do I wait? I've never been in trouble, so I don't.
Okay, let me read it to you. You are charged with criminal trespass, family violence, for knowingly and maliciously interfering with the victim's possession of their property at 852 Garden Walk Boulevard in unincorporated Clayton County. The offender and the victim, Jesse Smith, got into an argument on their residence. The offender took bags of groceries the victim bought and threw them outside of their apartment, causing a carton of tea to bust and become unusable. The offender is in a dating relationship. The offender and victim were in a dating relationship and have lived together since November of 2019. So that is the criminal trespass charge. Ma'am, you have a special condition not to violate any laws while you are out on bond, and also to have no violence or harassing contact with the victim, Jesse Smith. Do you understand that, ma'am?
Yes, ma'am.
All right, and since you have an OR bond, that will automatically waive your preliminary hearing, and you will receive your next court date in the mail.
Okay.
All right, thank you, ma'am.
Thank you so much.
All right, next, let me have Michelle Guzman.
No, that's somebody that's in medical, Judge. She's in medical.
Oh, she's in medical?
Yes.
All right, Lakeisha Hester. Give me just a moment. All right, good morning, ma'am. Are you Miss Hester?
Yes, I am.
All right, do you know what you're charged with?
No, ma'am.
All right, ma'am, you are charged with criminal trespass. Your bond is $1,500. Ma'am, do you waive formal reading of the charges? Do you waive formal reading of the charges, ma'am?
Could you explain that to me once again? I heard you say it the first time, but I really don't understand. Uh-oh.
Hold on. Judge, you're muted. Judge.
She wants to know if you want her to tell you.
She can't, no, she's talking and we can't hear talking.
I don't know the details.
We can't hear you.
All right, can you hear me now?
Yes.
Yes, ma'am.
Okay. All right, a criminal trespass for getting into a verbal argument with your wife and damaging the stair rails and damaging the front door by knocking and beating on the door, attempting to gain access into the house. Ma'am, your bond is $1,500. You have a special condition not to violate any laws while you are out on bond and to have no violent or harassing contact with Gladys Mejias. That's Mejias. Do you understand that, ma'am?
Yes, ma'am.
All right, ma'am. Do you believe that you will be able to post your $1,500 bond?
Yes.
All right. Thank you, ma'am. You may go with the deputy.
Okay.
All right, let me have Courtney Johnson. All right. Good morning, ma'am.
Good morning.
Do you know what you're charged with, ma'am?
Yes, ma'am.
Okay, simple battery, and your bond is $4,000, and cruelty to children in the 3rd degree, and your bond is $1,500. Do you waive formal reading of the charges, ma'am?
Yes, ma'am.
Okay. And you have, for your bond condition, to stay away and have no contact with George Laryeel, Laryeal, and also not to violate any laws while you are out on bond. Do you understand that, ma'am?
Yes, ma'am.
All right, ma'am. Do you believe that you will be able to post your bond?
Yes, ma'am. And another thing as well, the officer told me that him and the officer that came on the scene, that they would be talking with you about it, because he didn't, basically everything was kind of took out of context with the officer.
So you will need to speak with your attorney about that. So I have appointed an attorney. Okay. Make sure you relay that information to them.
Okay.
All right. All right. Thank you, ma'am.
Thank you.
All right. And now, Mr. Raymond.
Yes.
All right. Are you Terrence Raymond?
I am.
All right. Good morning, sir. This is what's called an extradition hearing. All of the rights that I have advised everyone of earlier also apply in your case, but your hearing is a little bit different from the first appearance because you do not have any charges pending here in Clayton County. You are being charged with being a fugitive from justice. You are wanted by Cuyahoga County Sheriff's Office for dangerous drugs. Warrant number W170693448, which is a felony charge. And do you know what what state that's in, sir?
Ohio.
In Ohio?
Cleveland, Ohio.
And they have been contacted and they wish to extradite you back on this charge. So, sir, do you already have an attorney representing you on this charge in Ohio?
I didn't know this charge was pending.
Okay. You have a choice as to whether you wish to contest extradition or waive extradition and be returned to Ohio without going through the formal extradition process. So if you decide to contest extradition, the court may commit you to our jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition back to Ohio. The court is not going to consider posting a bond for you at this time because you are wanted by another jurisdiction. If you do not wish to voluntarily return back to the state of Ohio, You may file a writ of habeas corpus to contest the extradition. You will only be able to contest 4 things. 1, whether the extradition documents are in order on their face. 2, whether you are charged with a crime that actually exists in Ohio. 3, whether you are the person named in the request for extradition. And 4, whether you are in fact a fugitive from justice. You will not be able to contest or address the issue of your guilt or innocence here in this state, since the case is pending in another state. You are entitled to the advice of counsel in contesting extradition, and I would appoint an attorney to you if you decide to contest extradition. If the state is unable to extradite you within 30 days, you may be committed to the county jail for an additional 60 days awaiting your extradition. If the extradition is not completed in 90 days, then you will be released. If you decide to voluntarily return back to Ohio, Ohio will have 10 business days to come here to pick you up from our jail. And if they don't pick you up within those 10 business days, then we will release you. Do you want to voluntarily return back to Ohio, or do you want to contest extradition?
I want to volunteer.
Okay, so there will be some waiver forms. Do you all have the waiver forms?
Yes, yes.
Okay. If you can go ahead and sign those waiver forms. And like I said, sir, they will have 10 business days to come here to pick you up from our jail. All right, next will be Hyle Cody. Ezekiel Cody.
Cody, Ezekiel. Everybody have a seat to your name is called. I'll be out the window. Out the window.
All right, and after Mr. Cody will be Justin Green. Good morning, sir. Are you Hyle Cody?
Yes, ma'am.
All right, good morning. Sir, do you know what you're charged with?
Yes, ma'am.
Okay. You are charged with DUI less safe. Your bond is $2,000, improper backing, $500, and hit and run, $1,500. Do you waive the formal reading of your charges, sir?
Do I waive it?
Do you waive the formal reading, or do you want your charges read to you?
I'm good. I don't need them read to me.
All right. And sir, you have a bond condition not to violate any laws while you are out on bond. Do you believe that you will be able to post bond, sir?
Yes, ma'am, immediately.
All right. Okay. Thank you, sir. You may be excused to go with the deputy. All right, Mr. Green, and after Mr. Green will be Marcel Huff. All right. Good morning, Mr. Green. Do you know what you're charged with?
No, ma'am.
Okay, sir, you are charged with battery, family violence, and your bond is $4,000. Do you waive the formal reading of the charges, sir? Or do you want them read to you?
Say that one more time, can you?
Do you waive the formal reading of the charges, or do you want your charges read to you?
I don't understand.
Okay, I will go ahead and read them to you.
Okay.
It says that you intentionally punched the victim, Judson Green, in the mouth with a closed fist. You punched the victim's mouth, left a visible mark on the victim's face. At the time of the incident, you and the victim were involved in a verbal disagreement. You're the son of the victim, and you all both reside at the residence, 7356 Mockingbird Trail in Riverdale. Sir, you have a special condition to stay away from Judson Green and not to return to or go upon the premises located at 7356 Mockingbird Trail in Riverdale. Sir, after you post bond, you will be able to contact the sheriff's office to schedule an appointment to get an escort to go back to the residence one time to retrieve your personal belongings. Do you understand that, sir?
Yes, but ma'am, that's what I live with. I don't have no.
Due to this battery, this family violence battery charge, you will not be able to go back to this residence. Sir, would you like to, sir, would you like to waive your preliminary hearing, or would you like to have a preliminary hearing?
Which one would be better? Like, if you're gonna get me back in, you're gonna get me in court quicker?
The preliminary hearing is scheduled for June 1st. If you waive the preliminary hearing, then you will have a quicker court date in front of a state court judge if you are still in the Clayton County Jail. So did you want to waive your hearing to expedite your case?
Would that be the best thing?
I can't give you any legal advice. You would have to speak with an attorney about that. So would you like to waive your hearing?
I don't want to take the wrong thing. Yeah, I guess I do. If you're gonna get me back in, if you're gonna get me in court, that means I don't. If you're gonna get me in court quick, I would do that. You know what I mean?
Okay. Thank you, sir. They will have you sign a waiver. And after that, all right. Thank you, sir.
Print your name right here at the top. Sign right here. Print your name at the top. If you're waiving, sign your name.
All right. And are you Mr. Huff?
Yes, ma'am, I am.
Come on, sir.
All right.
Right here.
And after Mr. Huff will be
You didn't do nothing wrong.
Aladel Makandula.
Ma'am.
I was just letting the deputies know. Next person will be Aladel Makandula. All right, Mr. Huff, do you know what you're charged with?
Yes, ma'am.
Okay, you are charged with criminal trespass, damage to property. Your bond is $2,500, and battery, family violence. You have no bond set on that charge because you're currently on 8 years probation out of Coweta County Superior Court. Sir, do you waive formal reading of the charges?
Formal reason?
Or do you want the charges read to you?
Can I say something? No, the only thing you need to
No, not about the case. You have to speak with your attorney about that. Do you waive formal reading of the charges, or do you want them read to you?
Can I read to me?
For the battery, family violence, it said that you did intentionally grab and place your arms around your mother, Kimberly Huff, face and body area, causing redness under her right eye area. All right. And for the, just a moment, for the criminal trespass, damage to property, it says that you did intentionally take Kimberly Huff's cell phone without her consent and deprive her usage of it as she attempted to contact emergency services. All right. All right, sir, would you like to waive your preliminary hearing?
Waive it, which in like,
Give me no advice, sir. Yes or no, that's it.
If you waive it, then your case will go to state court. If not, you will have a preliminary hearing in magistrate court on June 1st.
I waive it, I have it on June 1st. Preliminary here on June 1st, ma'am.
Would you like to have that hearing, or would you like to waive it?
I'd like to have the hearing.
Okay, so it will be set for June 1st at 8:30 in courtroom 201.
If I didn't waive it, ma'am.
If you bond out, sir, the hearing will automatically be waived by law, and you will get your next court date in the mail.
Yes,
thank you, sir.
Do I have a bond?
Thank you, sir. You have no bond because you're on probation. Mark Oladell, and forgive me if I'm mispronouncing your name, Marcangela. Yes. And next will be Kyrie Miller. All right. Good morning, sir.
Good morning.
How do you pronounce your name, sir?
Okay.
Sir, do you know what you are charged with?
Yes.
Okay. You are charged with terroristic threats. You have a $5,000 bond. Cruelty to children in the second degree, $5,000, and criminal trespass, $2,000 bond. Sir, do you waive the formal reading of your charges or would you like them read to you?
I'll waive it.
Okay. Sir, you have a special condition on your bond to stay away and have no contact with Talisha Magangela. Also, not to return to or go upon the premises located at 1079 Shieldcrest Way in Forest Park. And sir, after you've posted bond, you will be able to contact the sheriff's office to schedule an appointment to have an escort take you back to retrieve your personal belongings. Do you understand that, sir?
Yes.
Sir, do you believe you will be able to post bond?
Yes,
Okay. And sir, your preliminary hearing is scheduled for May 26th. You may want to write this down. May 26th at 8 o'clock in courtroom 203. Thank you, sir.
come on.
Right. Next, we have Kyrie Miller and then Claude Moore. Good morning, sir.
Good morning.
Do you know what you're charged with, Mr. Miller?
Yeah. Yes, ma'am.
Sir, you're charged with violation of the Georgia Controlled Substances Act, possession of marijuana with intent to distribute. Your bond is $5,000. And violation of the seatbelt law, your bond is $500. Sir, do you waive formal reading of the charges or do you want them read to you?
Read to me.
Right, sir. It says that you failed to use a safety belt in a passenger vehicle. The officer noticed that you were not wearing your seatbelt prior to making a traffic stop. Upon making contact, the officer noticed a strong odor of marijuana coming out from the inside of the vehicle. You stated to the officer that you had marijuana inside the vehicle. The vehicle was searched. 22.7 grams of marijuana were found in bags, individual bags in the back seat floor with a scale. All right, sir, do you believe that you will be able to post your bond?
Yes, ma'am.
Mr. Miller?
Yes, ma'am. You're breaking up.
Mr. Miller,
Yes, ma'am.
can you hear me?
Now I can.
Okay, I think the internet was kind of going in and out for a second. Okay, I heard that you said that you believed you would be able to post your bond. Sir, your preliminary hearing is set for May 26th at 8 o'clock in courtroom 203. And sir, if you bond out before that date, that hearing will automatically be waived by law and you'll get your next court date in the mail.
All right.
Thank you, sir. All right. Mr. Moore, Claude Moore. And after Mr. Moore will be Alan Newton. Alan Newton.
Yes. This is Mr. Moore.
All right. Good morning, Mr. Moore. Do you know what you're charged with?
No, ma'am, not exactly.
All right, sir, you are charged with violation of the Georgia Controlled Substances Act. Your bond is $5,000 on that charge. Possession of drug-related objects, $1,000 bond, and driving on a suspended or revoked license, $1,500 bond. Sir, would you like to waive the formal reading of your charges or do you want them read to you?
I want to read to me.
Sir, it says that you did drive a Toyota Camry bearing Georgia tag RLV 7644 while suspended as of September 25th, 2019 for driving while suspended or revoked. You also had a crack pipe and scale located in the driver's side door that you informed the officer of. When the officer searched your person, approximately 0.3 grams of crack cocaine were located in your pocket. Sir, do you believe that you will be able to post your bond?
I didn't get those bonds. I get the bond.
Write it down.
The total bond was $7,500 for all three charges. All right. And sir, your preliminary hearing is scheduled for May 26th at 8 o'clock in courtroom 203. May 26th at 8 in courtroom 203. Thank you, sir.
Come on, this way.
Yeah, I just have one question
Yes, sir. What's your question?
about the suspended license thing. I had
Oh,
done
I
this,
cannot answer any specific questions on the charges. You will have to speak with your court-appointed attorney. Thank you, sir.
Thank you.
All right, you're welcome.
Come on this way.
Alan Newton, and then next will be Xavier Parker. All right, good morning, sir. Do you know what you're charged with?
No, ma'am.
Sir, you are charged with battery and your bond is $4,000. Do you waive formal reading of the charges or do you want them read to you?
How much was the bond? I can't hear it. I'll speak now.
Hold on. Come on. Come on.
We can't hear you.
Okay, can you hear me now,
Yes.
Mr. Newton?
Yes, ma'am.
All right, so you're charged with battery and the bond is $4,000. Do you waive formal reading of the charges or do you want them read to you?
I'll go ahead and take the charges.
Do you want me to read the charges to you? Do you
Yeah.
waive? Okay. So it says that you committed the offense of battery when you intentionally caused substantial physical harm or visible bodily harm to Caleb Newton by grabbing his neck, leaving several red marks on the left side of his neck. It says that you all are father and son, and this happened in Clayton County. Sir, you have a special condition to stay away and have no contact with Caleb Newton and also not to violate any laws while you are out on bond. Do you understand that, sir?
I have to have a what?
Not to violate any laws while you are out on bond and also not to have any contact with your son, Caleb Newton. Do you understand that, sir?
Yes, ma'am.
All right. And do you believe you will be able to post your bond, sir?
Yes.
And sir, would you like to waive your preliminary hearing?
Yes.
All right, thank you, sir. You may go with the deputy. All right, you're Mr. Parker?
Yes, ma'am.
All right, good morning, sir. And after Mr. Parker is going to be Jesse Rosa. All right, Mr. Parker, you are charged with criminal trespass. Your bond is $1,500. I'm giving you a signature bond for that. So you will be released on your own recognizance. Sir, would you like to waive formal reading of the charges or do you want them read to you?
Read them to me.
All right, sir, it says that you admitted to being the primary aggressor by committing criminal trespass against the victim, LaQuanda Walker, when you stated you took her cell phone from her, preventing her from using her property until the police arrived at the incident location at 1953 Old Dogwood in Jonesboro. And the offense occurred in Clayton County during an argument that turned physical. Sir, you are to not violate any laws while you are out on bond and to have no violent or harassing contact with the victim, LaQuanda Walker. Do you understand that, sir?
Yes, ma'am. I got a question.
Yes, sir.
I live there, like we live.
Hold on. Okay. You can have contact with her,
Okay.
but it cannot be of a violent or harassing nature.
Gotcha.
If it is violent or harassing, then you can be rearrested for violating this bond condition.
Yes, ma'am.
All right. Okay. And since I am releasing you on your own recognizance, that's going to automatically waive a preliminary hearing and you will get your next court date in the mail.
I got another question too.
Yes, sir.
How long does this signature bond take?
That will be up to the sheriff's office. They will have to process you out after this hearing. All
Okay.
right. Thank you, sir. All right. Mr. Rosa, good morning. And then next will be the High Taylor. All right. Good morning, sir. Sir, you are charged with driving while unlicensed, violation of the Georgia Controlled Substances Act for possession of cocaine, and violation of the Georgia Controlled Substances Act for possession of MDMA. For the no license charge, your bond is $1,000, and for the 2 felony drug charges, $5,000 each, for a total bond of $11,000. Sir, do you waive the formal reading of your charges, or would you like to have them read to you?
No, I don't need them read.
All right. And sir, your preliminary hearing is set for May 26th at 8 o'clock in courtroom 203. May 26th at 8 o'clock in courtroom 203. Sir, do you think that you'll be able to post your $11,000 bond?
Yes, ma'am.
All right. Thank you, sir. You may go with the deputy. All right, Mr. Taylor, and after Mr. Taylor will be Anthony Wester. All right, good morning, sir.
Good morning.
Taylor, you are charged with theft by deception. Your bond is $5,000. Sir, do you waive the formal reading of the charges, or would you like them read to you?
I'll let them read to me.
All right, sir, it says that you did obtain property, a red in color Gretsch semi-hollow body guitar, model 7655, by an unknown means with the intention of depriving the lawful owner of said property. Said property being worth $1,500.01 or greater. Said property is worth $2,600 with the intent to deprive the owner of the property by pawning said item on December 23rd, 2019 at 14:50 hours, which I think would be 2:50 in the afternoon, and received $800 in exchange without being the rightful owner of said item. Sir, do you believe that you will be able to post your $5,000 bond?
I do, but I need to go to work. I have to work tomorrow, so I don't know how that's gonna work.
Okay, well, if this should allow you to make a phone call to call someone to be able to help you post bond. Sir, your preliminary hearing is set for May 26th at 8 o'clock in courtroom 203. May 26th at 8 o'clock in courtroom 203. Thank you, sir.
I got another question. I got a question.
Yes, sir.
Can you ask one of them to like get my phone, because they ain't letting me get no numbers on my phone.
Let's go.
Well, you will have to speak with the sheriff's office about that.
Okay.
Thank you, sir.
Appreciate it.
All right, Mr. Wester, and then next will be Sammy White. All right, good morning, sir. You're Mr. Anthony Wester.
Yes, ma'am.
All right. Sir, you are charged with simple assault. Your bond is $3,000, and criminal trespass. Your bond is $1,500. Sir, do you waive the formal reading of your charges, or do you want them read to you?
I'll waive the reading.
All right. Sir, you have a special condition to stay away and have no contact with Theodore Jenkins. Also not to return to or go upon the premises located at 1593 Ravens Run in Jonesboro. Do you understand that, sir?
Yes, ma'am.
Sir, do you have any personal belongings at that property, like clothing or other? Okay.
Yes, ma'am.
All right, so you will be able to contact the sheriff's office when you are released to schedule an appointment to get an escort that will take you back to the property one time to retrieve your personal belongings. You're also not to violate any laws while you are on bond. Do you believe that you will be able to post your bond, sir?
Yes, ma'am.
All right. And would you like to waive your preliminary hearing?
Yes, ma'am.
All right. So the deputies, they will have you sign the waiver. You are excused. Thank you, sir.
Thank you. You need to sign a waiver.
All right. And you're Mr. White?
Yes, ma'am.
All right. Good morning, sir. Sir, you are charged with simple battery, family violence. Your bond is $4,000. Sir, do you waive formal reading of the charges, or do you want them read to you?
I would like them read.
All right, it says that you intentionally caused physical harm to your girlfriend of 6 years, Rayona Buggs, by scratching her neck in an attempt to take her cell phone. Rayona lives with, you all live together at 5653 Alder Drive, and she had 3 scratches on the right side of her neck. Sir, you have a special condition to stay away and have no contact with Rayona Buggs, also not to return to or go upon the premises located at 5643 Alder Drive in Forest Park, and not to violate any laws while you are out on bond. And sir, you will be able to contact the sheriff's office to schedule an appointment to have an escort take you back to the property one time to retrieve your personal belongings. Do you understand that, sir?
Yes, ma'am. I have a question, but the purse, everything in the house is mine. So I can.
Okay, hold on, sir. Okay, due to the simple battery charge, you will not be able to go back to this location, but you can speak with your court-appointed attorney or an attorney that you may retain and let them know about the situation. They would have to file a motion and bring it before the court, where we would have all sides present, your attorney and the prosecutor. But right now, because it says that you all live together and this is where the simple battery occurred, you will not be able to go back to the location. Do you believe you'll be able to post your bond, sir?
Yes, ma'am.
Would you like to waive your preliminary hearing?
Yes.
All right, thank you, sir. They will have you sign the waiver and then you are free to go back with the deputy.
You said the bond was 4,000?
Yes, $4,000.
Step to your right here. Sign your waiver.
And that court,
Look, I'm in the
Oh,
middle.
you said that you wanted to waive it, so you will receive notice of your next court date in the mail.
yes, ma'am.
Come right here.
All right.
The name at the top.
And then we have the 2 people that are in medical left.
Yes, Your Honor.
Okay, Tia Ward and Michelle Guzman. All right.
That's right, but he's already done, man.
Uh-oh. Let's see, where did the sheriff's? Oh.
Bullshit.
Hey, hit it again. Hold on, y'all. Are we getting the inmate out now?
Okay.
Tell him try enough. Push! Push it! We can't hear you. Oh, that's good.
Hey, can you hear me now?
Yes, ma'am.
Okay. All right. And is this Tia or Michelle?
Michelle Guzman.
Hello? Can you hear me?
No thumbs up.
When you talk through the keyhole right here. Miss Guzman.
Can you hear me, ma'am? Can you hear me, ma'am?
No thumbs.
Okay. Good morning, ma'am. I'm Judge Xavier Fox. You, a court-appointed attorney. If you choose to retain an attorney, once they file an entry of appearance, then your court-appointed attorney will be relieved from representing you. Okay? I want to advise you of your rights. You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt, the right to indictment by grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and cross-examine all witnesses that are called to testify against you, the right to compel the attendance of witnesses in your own behalf by subpoena, the right to testify and offer other evidence in your own defense, the right to have an attorney represent you. You have the right to post bond. It may be cash, commercial, or a property bond. If you post a cash bond, you will deliver the full amount to the sheriff that will hold that cash bond until your final hearing. After the final disposition of your case, you'll receive all of that money back. If you decide to post a commercial property bond, you would pay up to about 15% to a bonding company. They would keep that money as their fee for their service. That money would not be returned to you. If you decide to post a property bond, you would need to find someone that has at least 3 times the amount of equity in their property as the amount of your bond. You'll have a special condition not to violate any additional laws while you are out on bond. You are charged with driving under the influence of alcohol, less safe, a $2,000 bond, and improper lane change, a $500 bond. Now, ma'am, let me see. Do you waive the formal reading of your charges, or would you like the charges read to you?
She waived.
Waive, okay, yes, ma'am. And you would have a preliminary hearing set for June 1st at 8:30 in Magistrate Court. A preliminary hearing is a probable cause hearing that is held here in Magistrate Court. If you would like to waive that hearing, it will expedite your case to state court. Would you like to have the hearing on June 1st, or would you like to waive that preliminary hearing?
Waive it.
All right, thank you, ma'am. And also, do you think that you will be able to post your $2,500 bond?
She's not
Okay,
find out.
I heard her. All right, thank you, ma'am. They will have you sign the waiver, all right? And your attorney will be in touch with you. Thank you, ma'am.
Yeah.
So that was Ms. Guzman, and then you all have Tia Ward.
Yeah, Judge.
Yes,
She's in her cell, but she's not really cooperating, but you want to try anyway?
yes.
All right. Yes, who has the key, Jameson?
'Cause I can't continue her till tomorrow. We don't have first appearance tomorrow.
Okay.
Is she there in medical, or do you all have to go somewhere else?
She's in medical.
Okay,
I have to unplug this in a minute. So I don't know what it's gonna do when I unplug it, okay?
okay.
Okay, I'll get it taken care of. They got a plug over there for this?
It's still on. I can still see the video.
Okay. I still gotta pull it or get it plugged in. I get it done.
Okay.
Plug it in right quick from the heart.
Well,
Right. Oh, this not a plug?
no, not a plug.
Oh, okay. Well, Judge, I don't have a plug, so there's one over there, but it's like the ways away.
But you know what? She still should be able to hear though.
She needs to have on some clothes, something, because
Put it on, Judge, that's what I'm telling you. She's not volunteer. She's not cooperating. Turn the video away from me. That's what I was saying. She's not cooperating. That's what's saying. She won't put the clothes on.
will you be able to turn the video off on your side where she can still see me?
Let me see if I can do that.
There should be a button at the bottom where you can just maybe stop the video on your side.
Yep, I can do that.
Okay, well, please put the laptop so that she can see me.
Okay.
So can you see the judge on there with that?
Is it facing her? Let me know when to begin.
Okay, I can't see. She won't be able to see you, Judge. I can't see you. She can't see you. Hold up.
She'll be able to hear me?
She can hear you. Yeah.
All right. All right. Good morning, Ms. Ward. I'm Judge Xavier Fox. I'm going to conduct your first appearance hearing this morning. I want to let you know what your rights are. You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt, the right to indictment by grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and cross-examine all witnesses that are called to testify against you, the right to compel the attendance of witnesses in your own behalf, the right to testify and offer other evidence in your own defense, and the right to be represented by an attorney. Ms. Ward, I am going to appoint an attorney for you. You're charged with simple battery, family violence. Your bond is $4,000. The warrant states that you did physically contact in an insulting nature with your daughter, Jayla Ward, by pulling her hair when the officer was present. It occurred at 772 Point South Parkway, apartment 1508 in Jonesboro. Ma'am, your bond is $4,000. You have a special condition not to violate any laws while you are on bond, not to have any violence or harassing contact with Jayla Ward, and no corporal or physical punishment of Jayla Ward. Ma'am, you can post this bond, cash, commercial, or property. If you post a cash bond, you will pay the $4,000 in cash to the sheriff, along with any applicable fees. That will be held until your final disposition of your court case, where the money will be returned back to you. If you do not have a full amount in cash, and you can go through a commercial bonding company. They charge typically up to about 15% of the amount of your total bond, and that money will not be returned to you. It will be the fee for your service, for their service. Or if you post a property bond, you would need to find someone that has at least 3 times the amount of equity in their property as the amount of your bond. And I'm going to set the preliminary hearing for June 1st at 8:30 in courtroom 201. Ma'am, if you bond out before June 1st, then that preliminary hearing will automatically be waived, and you will get your next court date in the mail. And ma'am, you will also receive a copy of your bond order that has your special conditions on it. All right, thank you. So that concludes Ms. Ward's hearing.
Okay, all right, Judge. That's it, right?
All right, that's it. You all have a good day.
You too, Judge.
All right, take care.
All right.
Bye.